done so, adhere to it, will be ready to face the consequences for failing to do so. I remind counsel of what one commentator called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
Court, all right.
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel the criminal fourth session.
Court stands in recess.
There's no opportunity to be heard?
There obviously no opportunity to be heard.
I was unaware. I'm just covering for a clerk benefit today.
Is there an opportunity before everybody departs to let the judge know that we would like to be heard?
I absolutely.
Uh-oh. Well, that was a very interesting hearing by Judge Gildea in the Plymouth Superior Court. Welcome to the Margaret McLean Show. This is just a brief afternoon show explaining exactly what happened here in court. So basically, the judge came out, the attorneys were present as he told them to be, and we never found out who leaked this sensitive information in violation of the court's protective order in this civil trial against Karen Reed and the two bars. As you know, I'm a former prosecutor, civil trial lawyer, and law professor, so I'm trying to piece it all together. And basically what we're looking at is the judge wants to protect the integrity of the court. Someone leaked private information on a non-party deponent, and that would be Michael Proctor. And it sounds like it was on highly sensitive medical information. All of the parties and the lawyers involved swore under oath that they did not leak this information. So we don't really know who did it. But what the judge did was he talked about some of the rules that us attorneys have to abide by. For example, Rule 3.6, if you disseminate this type of information to people like me, online, different outlets, or whoever it may be, and it becomes public, you're really hurting the integrity of all parties involved. And I noticed when he was speaking, he was talking about, sort of behind the scenes, well, not really behind the scenes, but I noticed he said it's not fair to the person, even if we don't like that person. He didn't really say that, but he insinuated. So I believe that we're talking about Michael Proctor, and we don't like his vile texts and all the horrible things that came out. He's a disgraced trooper, but does he deserve to have private medical information, whatever that may be, disseminated to the public? No, he doesn't. So the judge is basically saying, look, we have to treat people who sometimes we don't like, with respect, and we have to follow the rules. So that was a big admonishment, and I think it was well deserved. Yeah. So let's see what some of you guys say. Not that it, oh, spells AJ, maybe, I don't know. It could be Ellen Jackson. It really could be anybody. It could be one of the parties or someone leaked information they shouldn't have. But the judge was also very clear about there will be sanctions if they find out if any more of the orders are violated. You can be found in contempt. You might be brought up before the bar. You might be disbarred as a lawyer if it's egregious enough. And also, it's interesting because he is still staying discovery as far as Proctor goes. So he has discretion. He was going on and on citing cases. I think he cited 4 or 5 cases saying that as the trial judge, he has discretion over this matter. He has the right to control the courtroom. So he's not allowing the deposition to go forward. And that's his right to do that because someone violated this. So he's sort of putting down, striking that gavel and saying, I'm going to be the boss here and I'm going to control my courtroom. So that's about it. And I do like this judge. I think he's fair. He's got a lot of lawyers to control. And he did remind everybody there is a deadline in this case. So, and he's going to stick to that deadline. That means all of these depositions, and there's a lot of depositions, must be taken by the deadline. No more excuses, ifs, ands, or buts. That's what's going to happen. So everybody have a wonderful 4th of July weekend. I will be coming to you live tomorrow at noon. So I'm trying something new. It's lunchtime law, where midday I talk about what's going on in law, what's going on with trials. And of course, I'll discuss this case tomorrow in more detail and talk to a little bit more about the cases and the rules. And I'll see you tomorrow live at noon. And please subscribe if you would like to check out those noontime shows. And I also will bring you shows live later in the evening with awesome guests. So once again, thanks for being in the chat. I don't have a big show with a lot of chat yet, but I am building. And thank you very much. I appreciate you in the chat. So, and I will talk to you soon. I'll see you tomorrow. And think of some questions you may have regarding this hearing or anything else with the 4 cases that came out of the Karen Reed trial. Talk to you soon. Have a nice afternoon.